Hello, this is Marvin Strong. This week's chapter summary video is on chapter 21, which is about environmental discrimination, and chapter 22, which is about environmental law. And employment at will doctrine refers to the presumption that employment is for an infinite period of time and may be terminated either by the employer or employee. This is the historical approach that courts have taken in interpreting employment relationships. Uh, the three major common law exceptions are public policy, implied contract, and implied covenant of good faith. The at-will presumption is strong. However, it can be difficult for an employee to prove that his circumstances fall within one of the exceptions. There are 6 federal statutes prohibiting discrimination in employment. The Civil Rights Act of 1866, enacted April 9, 1866, was the first United States federal law to define citizenship and affirm that all citizens are equally protected by the law. It prohibited discrimination on the basis of race and ethnicity. The Equal Pay Act of 1963 is a United States labor law amending the Fair Labor Standards Act, aimed at abolishing wage disparity based on sex. It was signed into law on June 10, 1963 by John F. Kennedy as part of his New Frontier program. The Civil Rights Act of 1964 is a landmark civil rights and U.S. labor law in the United States that prohibits discrimination based on race, color, religion, sex, or national origin. It also prohibits unequal application of voter registration requirements, racial segregation in schools, employment, and public accommodations. The Age Discrimination in Employment Act of 1967 is a U.S. labor law that forbids employment discrimination against anyone at least 40 years of age in the United States. In 1967, the bill was signed into law by President Lyndon B. Johnson. The Rehabilitation Act of 1973, as amended Rehab Act, prohibits discrimination on the basis of disability in programs conducted by federal agencies, in programs receiving federal financial assistance, in federal employment, and in the employment practices of federal contractors. Passed by Congress in 1990, the Americans with Disability Act, or ADA, is the nation's first comprehensive civil rights law addressing the needs of people with disabilities, prohibiting discrimination in employment, public services, public accommodations, and telecommunications. Some examples of discrimination in the workplace include when an employer, supervisor, or coworker treats another employee unfairly based on religion, age, ethnicity, gender, disability, skin color, or race. Chapter 22, there are alternative approaches to environmental protection, government subsidies approach, and emission charges approach. With the government subsidies approach, the government pays polluters to reduce their emissions. A disadvantage is firms that limit pollutants must still pay the difference between the actual cost and subsidy, while the emissions charges approach charges the polluter a fee on every unit of pollutant discharged. A disadvantage is that licensing is a continuing wrong. The marketable discharge permits approach is where the government sells permits for the discharge and pollutants, where polluters could be encouraged to reduce emissions so that they may sell their permits. The direct regulation approach specifies limits on the amount of pollutants that can be discharged. Technology forcing standards set primarily on the basis of health considerations. Technology-driven standards attempt to achieve the greatest levels of improvement with existing technology. The Environmental Protection Agency is a federal agency responsible for conducting an integrated, coordinated attack on all forms of environmental pollution and operates under a policy statement. Its agents look for significant environmental harm and culpable conduct.